Alright, Conductor Certification Final Ruling 11111, Code Federal Regulation, Part, Title 49, Part 242, 501, Subpart F, Dispute Resolution Procedures 242-501, Review Board establish any person who is denied certification, denied recertification, or has his or her certification revoked, believeth the railroad incorrectly determined that he or she, meeting of the certification requirements of the regulation, will make a decision to deny the revoking, may petition the Federal Railroad Administrator to review the railroad decision. The administrative has delegated an initial responsibility for the junction such as disputing an operating review board. The operating crew review board shall be composed of employees of the Federal Railroad Administration selected by the administrator. This is 242-503. The petition requirements to obtain a review of the railroad decisions and to deny certification, deny the recertification, revoke certification. A person shall petition the review that complies with the section. Each of the petition shall be in writing. 1, 2, docked in the clerk of the U.S. Department of Transportation dock operations at M330 West Building ground floor, the room 412, 140, 1200 New Jersey Avenue, Southeast Washington, D.C. 20590 for the form and such request as must be in written and electronic consistent with standards of the requirements established within the federal docket management system are posted on the website with www.regulations.gov containing all the information with the person thinking and the supporting personal belief the railroad action properly, including 1, the petitioner's full name, 2, the petitioner's currently mailed address, 3, the petitioner's daytime telephone phone number, 4, the petitioner's email address if available, 5, the name and address of the railroad, 6, the fact of the petitioner believes to constitute the improper action of the railroad, specifying location, dates, and identifying all persons who were present involving the railroad action, the degree known of the petitioner, 4, the explaining the nature of the remedial action sought, 5, there must be supplemented a copy of all written documentation, petitioner's possession, responsibility, availability, petition, documentation, railroad decision, and 6, be filed in timely manner. 7, be submitted to the operating crew review board with a copy of the information in Title 49 CFR 43.229, laboratories, medical reviews, officers, other service agreement agents required to release the employees. The petitioner must provide with a written explanation of the operating crew review board. Request the written documentation shall be responsibly available to the petitioner as supplied. See a petition seeking revoke of the railroad decision to deny the certification, revoke certification in accordance with the procedures of Statute 242-407 filed with the FRA more than 120 days after the railroad's denial of the revocation decision were served, and the petitioner will be denied untimely except for the operation crew of the review board for the cause shall be made extend the petition and filing period of any time this discretion. 1. Provide the requesting extension is filed before the expiration of the period provided with the paragraph. 2. Provide the failure to the timely will result excusable neglect. Any part of the aggravated with the board decision to deny a petition untimely and non-compliance with the requirements of this section may file an appeal with the administrative in accordance with section 242-511. 242-505, processing certification review petitions. Each petition shall be acknowledged in the writing with the FRA. Acknowledgement should contain the docket number assigned with the petition. Statement of the FRA intention that the board will attempt to render the decision of the petition within 180 days of the railroad response received with the report of the date upon the railroad response period with the lapse pursuant to the paragraph C of the section. B, upon the receipt of the FRA will notify the railroad that it has received the petition where the petition has been assessed, and within 60 days of the date of notification provided and with the paragraph B of the section, the railroad may submit the FRA information with the railroad considered pertinent to the petition. Later filings will only consider the extent of the practical. Railroads shall submit railroads that submit such information identifying the petitioner name, the docket number, the review, the proceeding, preventing the railroad and email address, if and available, to serve the copy of information submitted with the FRA petitioner representative, if in any file information docket, clerk, U.S. Department of Transportation docket operations M30 West Building ground floor, the room 412, 140, 11200 New Jersey Avenue, Southeast Washington, D.C. 20590. This form, such information written or electronic forms consistent with the standard requirements established by the Federal Document Management System based on the website www.regulations.gov. Each petition will then be referred to the operating crew review board for a decision. Based on the record, the board shall have the authority to grant, deny, dismiss, and remand remand the petition. If the board finds that the insufficient basis of the granting, denying the petition, the board shall issue an order affording the parties the opportunity to provide additional information, argument inconsistent with its findings, standing review for factual issues. Then, considering the factual issue, the board will determine whether the substantial evidence to support the railroad's decision or negative finding in the ground granting the petition. Standard review the procedural issue. When the considered procedural issue, the board will determine the substantial harmful was caused by petitioner virtue of the failure to identify, adhere to the directed procedures making the railroad decision. Defining substantial harm is ground of the reversing the railroad decision to establish grounds upon which the board may grant relief, and the petitioner must say, show 1. The procedure error occurred. 2. The procedure error caused by substantial harm. J. The standard review of legal issues pursuant to the review of the rule. Board will consider the railroad's legal interpretation as corrected by the de novo rule. Review. The board will determine it within denial, revocation of the certification, recertification, improper with the regulation EI, etc. Based on the incorrect determination, person failed to meet the certification requirements of the regulation, granted, denied the petition according with the board of the board will not otherwise consider property as the railroad decision. It will not consider whether the railroad properly applied to the more stringent requirements. L. The board written decision shall be served in the petitioner, including the petitioner representative, if any, of the railroad. 242-507 requesting a hearing. Adversely affected with the operating crew review board decision, either the petitioner before or the board of the railroad is involved should have the right to administrative proceeding prescribed in 242-509 to exercise the right adversely affected with the party shall within 20 days serve as the board decision. Party will apply written of the docket clear use Department of Transportation docket operations M30 West Building ground floor room 1 W12 140 to 1200 New Jersey Avenue Southeast Washington DC 20590 with a form of such request may be written in electronic form consistent with the standard requirements established with the Federal Docket Management System posted on the website at www.regulations.gov. If any of the parts require the hearing of the period provided with the paragraph B of the section operating crew reviews, the decision will constitute with the final agency action. If the party elects to request a hearing, the person shall submit a written request for documentation containing the following: the name, the address, telephone number, email address of the respondent and the requesting party's designated representative, if and any, the specific factual issues, the industry rules, regulations, laws, the requesting party allergies needed to necessary to examine in the connection of with certification and this question. In question, the signature and requesting party the representative upon receiving the hearing requesting complying with the part of paragraph D of the FRA shall arrange the appointment of the presiding officer who shall schedule the hearing of the earliest practical date. 242-509, the hearings. An administrative hearing for the conductor certification petition shall be conducted with the presiding officer who can only be a person authorized by the administrative, included by the administrative law judge. The presiding officer may exercise the power of administrative to regulate the conduct of the hearing for the purpose of achieving prompt and fair determination of material issues of controversy. The presiding officer shall convey the presiding of the overhearing of the hearing shall be done in de novo hearing of the relevant facts, determining the correct application of this part of the fact. The presiding officers may determine that there is no genuine issue covering some all materials, facts, and limited evidentiary proceedings of the issue and the material fact which was genuine dispute. The presiding officer may authorize dispute over types of quantity which presiding officer's discretion will contribute with a fair hearing without unduly burdening parties. With the presiding officer may impose the appropriate non-monetary sanctions, the limitations of the presentation, evidence issues for any parties willfully fair and a refusal to comply with the approved discovery request. Every petition, motion, response of the other authorized required document shall be signed and part of the filing same and by duly authorized officer represented with the record by any other person, if such by other person reason for there must be stated by the power of attorney and other authorization of such other person to subscribe the document will be filed and the document. The signature subscribing any document constitutes certification that he or she has read the document and that to be the best of the knowledge, information, belief that every statement that contained in the document is true, but no such statement is misleading, that it is not interposed in delay of the vexatious. After the request of the hearing is filed, with all documentation filed and served up to one part of the served up all parties, each party is designated with the person who serves and made by the specified by the law, regulation, and directive presiding officer. If the party does not designate a person who serves and is to be made, the service may be made upon the person having subscribed submission of the party being served, unless otherwise specified by the law, regulation, directives presiding officer. The proof of service shall accompany all documentation while they are tendering the filing. If any of the documentation in the initiating field and service and prior to the need not substantial compliance with the applicable law, regulations, and directive, the presiding officer may strike, dismiss all part of such documents as required and it is amended. H. Any part of the proceeding may appear to the heard in person by an authorized representative. I. Any person testifying, hearing, deposition, accompanied with the representative vice of the attorney, other representative may be examined. Any part of the request consolidated, separated, hearing to the more positions by motion of the presiding officer when they arise at the same or similar facts matters of any other reason redeemed efficiently heard together. Okay, except for provided in 242.507 paragraph 4 C in paragraph U4, the section which whenever a party has a right to the required take an action prescribed in this part of the law, regulation, directive, the presiding officer may extend this period with or without notice of good for a good cause, provided another party with non-substantial prejudice by such extension. A request extended for the period which has been already expired may deny untimely. Any application presiding officer for any order ruling no otherwise specifically provided in this part of them shall be in the motion. The motion shall be filed with the presiding officer and written with served upon all parties. All motion, unless during the hearing, shall be written in the motion that during the hearings may be made orally on the record, except for the presiding officer and direct for the oral motion be reduced. In writing and motion shall be particularly grounds, therefore the relief of the order shall be accompanied with the affidavits or other evidence desired to be relied upon, on which is already part of the record of any materials for response in the written motion must be filed served within 14 days of the motion and within such a period as directed by the presiding officer. And testimony witnesses hearing shall be given under the oath, and hearing shall be recorded in the verbatim. The presiding officer shall be given the parties in the proceeding adequate opportunity during the course of the hearing of the presentation of arguments in support of the or in opposition of motions, objection, exemptions, and rulings to the presiding officer. The presiding officer may permit oral argument of any issues the presiding officer deems appropriate or beneficial. Any evidence or argument received and proffered orally shall be transcribed and made for the part of the record. And physical evidence, written argument, and of evidence preferred shall be made as a part of the record, except for the presiding officer may authorize substitution copies, photographs, descriptions, whom deemed appropriate. And presiding officer shall employ full federal rules of evidence, United States Court Magistrates, and general guidelines in introduction of evidence. Notwithstanding M to the section, all relevant probative evidence shall be received unless presiding officer determines the evidence to unduly repetitive, so extensively lacking relevancy that the omission would impair the prompt or orderly fair solution of the proceeding. Presiding officer, administrative oath, affirmations issuing the subpoena provided in the 2097 of this chapter, adapt only any of the procedures in the submission of evidence written in the form, examine the witness of the hearing, convey, recess, adjourn, otherwise regulate the course of the hearing, and take any other action consisting with the provision of this part permitted by the law to expedite the hearing and aid the proceeding. P. The petitioner of the operating crew review board of the railroad involved with the certification action, the FRA shall parties of the hearing parties may participate in hearing may appear to be heard on the behalf through the designated representatives. All parties of other relevant evidence, including testimony, may conduct the cross-examination of the witnesses, be required to make a record of the relevant facts. Q. The part of the requesting administrative hearing shall be a hearing of the petition. The hearing petitioner shall have the burden of providing with the case by the predominance of the evidence. Hence, in the hearing of the petitioner railroad, if involving the certification action, the railroad will who have the burden of proving the decision of denying certification, denying recertification, or revoking certification was correct. Conversely, with the petitioner, the operating crew review board is the hearing. Petitioner, the person will be burdened with the providing with the railroad decision to deny certification and deny recertification certification and revoke certification which is incorrect. A person who is not adhering in participation with the respondent or the FRA will mandatory administrative hearings at the start of each proceeding. The FRA will respond as to the record of the proceeding shall be disclosed into the closure of the evidentiary hearing unless the presiding officer allows additional time for the submission of additional evidence. In such instances, the record shall be left upon such time the presiding officer grants for the purpose. At the close of the record, the presiding officer shall be written with the decision proceeding. The decision shall contain the finding of the factual conclusion as well as the basis concerning the material issue of the factual law, or as the record too shall be served in the hearing petitioner or other parties of the proceeding. 3 shall not become